Hi, my name is Mombi, and today I want us to deal with loans, charges, and the Duplum rule. So for loans is where you go to a bank or an institution that grants loans, this are called microfinance, and you request for money, and you give a security. For today, we are going to learn about loans where the security is land. So when you're given money, of course you're requested to pay with an interest for a specified amount of time, and of course you deposit a security. Where it is land, your land will be charged, there will be an encumbrance on your land. So there are two types of charges. There is a informal charge and formal charge. Informal charge is a written and witnessed undertaking. The intention is to charge your land. Of course, the purpose is to secure payment of money. For an informal charge, it is not registered. If you go to the land register, it won't reflect on the register. Even your title, it won't reflect on your title as an encumbrance. Okay, for an informal charge, you have to deposit a certificate of title, a certificate of lease, any document that proves that you are the owner of land. The best thing about the informal charge is that the bank or the institution cannot take possession or sell your parcel of land in case of default without an order of court. They have to get an order of court. That is the best thing about an informal charge. So that is the informal charge. Written and witnessed undertaking. Of course, the intention is to charge your land for securing payment of money. Number 2, it is not registered. Number 3, if you are in default and you continue to be in default for 1 month, the institution, the bank, SACCO, all those, they cannot take possession of your land or sell your parcel of land without an order of court. That is an informal charge. Now we come to formal charge. Formal charge is where it is of course you have to sign a charge document and your parcel of land is charged. Number 1 is that the formal charge, it is registered and it takes effect only after registration. It takes effect only after registration. So it will be reflected on the register. If you go to do a search, you will see it will be registered as a charge of that parcel of land. Even your title deed, it will say that in the encumbrance section, it will state that the land is charged and it has an encumbrance. For this one, for the formal charge, there is no need to go to court for an order. No, there is no need. So, you have taken the loan, your parcel of land is charged. You know the interest, they vary from time to time. So according to the Land Act, when there is a variation of interest, when the interest is reducing, it is increasing, the bank has to give you a 30-day written notice of the increase or decrease of the interest, and also to inform you the new rates. That is variation of interest. Whether it reduces or increase, the bank or the institution that grants loan has to give you a written 30-day notice of increase or decrease of the interest and the new rates. So for charges, when it comes to matrimonial properties, matrimonial property is defined in Section 2 of the Matrimonial Properties Act as the properties that are owned or leased by one or more spouse, where you are staying or you are utilizing it as your family home. You see, that land that is your matrimonial, that land where you stay, where you have been staying, you have stayed for so long, that land which is considered as matrimonial property, that one, it cannot be charged unless the spouse gives his written consent. So the institution has to ensure that the spouse has given a written consent. I'm going to give you an example of a case. It's called Barclays Bank versus O'Brien, where the transaction was challenged based on the fact that the spouse did not get an independent legal advice. It was challenged because the spouse, one of the spouse, did not get an independent legal advice. So when you want to charge parcels of land, this is for banks or institution, make sure that spousal consent is granted. There is a written consent from the spouse, and the spouse has been given independence from an advocate or from anyone who may advise her of the legal consequences in case of default, or the nature of charge, the consequences, all about charges. So that when she's allowing the matrimonial property to be charged, she's aware of what she's entering into. So make sure there is consent, and also there is independent legal advice, that the spouse is advised accordingly. So that is for the matrimonial properties. So let's say you have been paying your loan, but it gets to some point, like now due to COVID-19, your business is not doing well, so you are in default, and you continue to be in default for 1 month. You are in default and you continue to be in default for 1 month. The bank can exercise several remedies that are provided for in the Land Act. Number one of the remedy is power of sale. They can sell your land. Power of sale. Number one, before even they sell your land, they have to give you a 90-day statutory notice. 90-day statutory notice informing you the nature and extent of the loan. Number one, informing you the amount that you need to pay. Number one, the nature and extent of the default. Number two, informing you the amount that you need to pay to rectify the default. Number three, the consequences. They will also tell you that they can exercise either one of the remedies available to them. Now here is the power of sale. So the number one, they have to give you a 90-day power of sale. Number two, after 90 days, they have to give you a 40-day notice of intention to sell your parcel of land. Notice of intention to sell your parcel of land. 40 days notice of intention to sell your parcel of land. These two notices, they are mandatory notices. They are mandatory. They have to serve you and they have to give you these two notices. The purpose of these two notices, you see, you have 90 days and 40 days. So you have time. They are giving you time to redeem your property. You know, you have you as a person, I'm the borrower, you have we call it the equity of redemption. You are given time to redeem your property. Go there, look for money and pay within 90 days and within these 40 days that you have been given by the bank. That's why it is called mandatory statutory notices. The 90-day notice and the 40-day notice, they are mandatory. Mandatory. They have to serve you with those two notices. So after they have served you those two notices, you are still in default, you have not rectified the default, then of course it will be taken to the auctioneers. The auctioneers will serve you with a 45 days notification of sale. They are notifying you that they are going to sell this parcel of land in 45 days. So they are giving you a 45 days notification of sale. So that is the auctioneer. So you are still in default. After 45 days has lapsed, now the bank can exercise several things. Number one, they can sell either your whole land or a part of it. They can decide to sell the whole of your land or a part of it. Number two, they can subdivide. Number three, they can sell through a private contract. Number four, they can sell through auction, public auction. They can exercise one of that. So the bank the institution, they owe you a duty of care. They owe you a duty of care. When selling your parcel of land, they have to get the best price, the best reasonable price in the market. The best reasonable price. And they cannot sell your land for less than 75% the value of your land, the market value. They cannot sell it for less than 75% the market value. And this duty of care, it is very important, because let's say your parcel of land can be sold at 90%, but they sell it at 75%. You see, they are still in breach. They should ensure that they fetch the best price possible. Best price possible. And that's why in all these, when they're accessing their power of sale, they have to do a valuation. They have to engage the valuer, registered valuer, who will conduct valuation of your land. The valuation report will show the market value of that land and the forced value. So the market value and the forced value. They can sell, okay, they can sell with the forced value. They can also sell at the market value. Yes. So you have also to be supplied with a valuation report. And the report must show the forced value and the market value. Even you as a borrower, you can even engage your own valuer to do the valuation on your parcel of land, so to ensure that your parcel of land is sold at the best price possible. That is the duty of care from the bank, to sell your parcel of land at the best price possible. So that is the power of sale. Power of sale. Number two, the other thing that the bank can exercise, they can sue you. Number one, they can sue you when the security is not enough. Maybe your parcel of land, it is not enough to fetch the amount of money that you are given. They can sue you. Or number one, that maybe your property has devalued. It has devalued. So the property for now is not, the security, the amount of money is not enough. So they have to sue you for the amount that is on top. Number three, maybe you are the owner of land, but you have lost your land, maybe through a court case, so you are no longer the owner. They can sue you for that amount of money. The other number three, the remedy they can exercise is that they can appoint a receiver where your property is generating rent or income. They can appoint a receiver to be collecting the income, rents. Yes, they can appoint a receiver. But before they appoint a receiver, they have to give you a 30 days notice. 30-day notice that they are appointing a receiver who will be collecting the amount of money, the income on your property. The other thing, number four, is that they can lease your property. They can lease your property, and before they lease, they have to give you a 30-day notice. They have to give you a 30-day notice. And they cannot lease it for a term exceeding 15 years. They cannot lease it for a term exceeding 15 years. The other one is number five. Okay, power of sale. They can appoint a receiver. They can sue you. They can lease. Number five, they can take possession of your land. And by taking possession, they also have to give you notice. They also have to give you notice. So we go to those are the remedies that the bank can exercise. Okay, so we have to go to the reliefs. Okay, these are the reliefs. Let's say for you as a borrower, you are aggrieved because the bank is the institution is selling your parcel of land, and they never granted you notice, those mandatory notices. They never granted you mandatory notices, and they are selling your parcel of land. So you can go to court and sue to stop this process of sale. Number one, if they have not served you with these two mandatory notices, if they have not served you with these two mandatory notices, the whole process is a nullity. The whole process is a nullity. So when you go to court, you can be given an injunction to show, of course, to stop the sale. You can be given an injunction to stop the sale. That is number one. And of course, the whole process, if the case is hard, the whole process will be repeated. That is the number one. You see, for the mandatory notices, they have to serve you either personally, and they have to serve you through, and they serve you personally, or they can do it through the poster. They can send through poster. And when they send through poster, they have to ensure that you received, you collected, and you collected from the post, and you have to bring evidence that you received and collected those notices. Otherwise, it will be on them to prove that they served you. So when matrimonial property is charged, like we have said, there is also, you can apply for relief, where you in case you are in default, you can ask the court to reopen the charge. You can ask the court to reopen the charge, to vary or modify the charge. That will be at court's discretion. They can reopen the charge, they vary the terms, they vary the charge, they modify at the court's discretion. So that is the charges. So we are going to learn about the Duplum rule. The Duplum rule is a very interesting rule and meant to protect you as a borrower. So make sure you use it when the opportunity comes. The Duplum rule is where the interest should not exceed the principal amount. The interest charged by the bank should not exceed the principal amount. If you borrowed a loan of 1 million, the principal should not exceed 1 million. Actually, the interest should stop accruing when they reach the same level as principal amount. They should not exceed the principal amount. And this, of course, this rule sets the maximum amount of money that the bank can recover from the borrower. It also limits the bank from the amount of money it can recover from the borrower. So the Duplum rule it's found in section 44A of the Banking Act. So section 44A of the Banking Act. Actually, I'm going to use this case. It's Civil Appeal number 153 of 2017. The judgment was delivered on 3rd April 2020. And I'm going to take you through the Duplum rule using this case. Okay, section 44A2. I'm going to quote verbatim section B. It states, interest in accordance with the contract between the debtor and the institution not exceeding the principal owing when the loan becomes non-performing. So when you are in default of paying the loan, and of course the loan becomes non-performing. So when the loan becomes non-performing, the interest should not exceed the principal amount. The interest should not exceed the principal amount. This rule is meant to protect you as a borrower. The best thing about the rule, the Duplum rule, is that this section came into effect in 2007. However, we're going to section 44A6, and I quote it verbatim. This section shall apply with respect to loans made before this section came into operation, including loans that have become non-performing before this section comes into operation. What does this mean? It means that this rule applies retrospectively. It applies to even those loans that were taken before 2007. It applies to loans that were taken in 2001, 2000, 2005. It applies to even those loans. That is the Duplum rule. It applies retrospectively. Okay? That is the Duplum rule. That is the best thing about this rule. That you won't be exploited by institutions or by banks who give you exaggerated amounts of money. When like you took a loan of 1 million, then they slap you with 5 million interest. No. Just run to court and say that and claim this Duplum rule. This rule will be applied. Okay? So I'm going to rely on this case. There's a case that the Court of Appeal judges relied on this case called Mwabenja Ranchi Company Limited and another versus Kenya National Capital Corporation. It's 2009. It states in Duplum rule, its key in quotes, its key aim was to protect borrowers from exploitation by lenders who permit interest to accumulate to astronomical figures. That is number one. to protect you as a borrower from the lender, from the bank, any institution that grants loan, from because they permit interest to go so high that it is ridiculous. It is just exaggerated. So they protect you as a borrower from interest going too high, the interest surpassing the principal amount. That is number one, and I'm going to repeat it again. Number one, its key aim was to protect borrowers from exploitation by lenders who permit interest to accumulate to astronomical figures. That is number one, to protect you as a borrower so that interest does not go too high. Number two, it was also meant to safeguard the equity of redemption and safeguard against banks making it impossible to redeem a charged property. So they are protecting and safeguarding your equity of redemption. Remember when I said when you are given 90-day notice and the 40-day notice, that is the time to redeem your property. That is the best time to redeem your property. So they are protecting that time and they are protecting your equity of redemption so that the interest is not too high that you won't be able to redeem your property, to pay them so that they don't sell your property, exercise any of the remedies that I talked about. Yeah? So they are safeguarding your equity of redemption. These are two roles: to protect you from the bank who increase interest to astronomical figures. That is number one. Number two, to safeguard your equity of redemption, so that bank they don't the interest is not they don't make the interest too high that you are unable to exercise your equity of redemption. So that is the purpose, the way they protect you. I love this rule. I love this rule, and it protects you as a, and if they are in breach of this rule, go to court. Go to court and you're going to get your orders, and make sure you state they are in breach of this in Duplum rule. In Duplum rule. So that is the purpose. This case was delivered on 3rd April 2020 by Court of Appeal judges. Thank you. That is the in Duplum rule. Thanks.